Welcome to today's webinar, Empowering Workers to Sue Employers for Health and Safety Violations. I'm Brian Gum, the Communications Director at the Center for Progressive Reform. CPR is an action-oriented think tank that leverages a national network of law professors and other academics with a team of analysts to drive public policy for a just America. Working alongside public interest groups and frontline communities, CPR builds policy tools and strategies to inform policymakers and support people and communities on critical issues related to health, safety, equity, and the environment. We are also looking ahead, envisioning the future direction of sound policy to protect the public, make our government work for us, and build a better, more sustainable future. You can learn more on our website at www.progressivereform.org. Today's webinar will be moderated by CPR Senior Policy Analyst Katie Tracy. Katie, over to you.
Thank you, Brian. Hi, I'm Katie Tracy. I'm the Senior Policy Analyst at the Center for Progressive Reform. As Brian said, I'll be moderating our panel today. And just a quick introduction. Since the Occupational Safety and Health Act was enacted over 50 years ago, we've made really great strides toward protecting worker health and safety in this nation. One shortcoming of the statute, however, is that it does not provide workers an independent right to enforce the law, even when federal OSHA or its state or territorial counterparts fail to inspect or issue citations. So today our panelists will discuss the need to provide workers with the right to sue their employers for dangerous working conditions and what that legislation would look like. So please allow me to introduce our panelists. Solma Guzman is a social justice attorney at Centro de los Derechos del Migrante. CDM assists Mexico-based migrant workers in defending and protecting their rights as they move between their home communities in Mexico and their workplaces in the United States. At CDM, Solma advocates for workers' rights at both the federal and state level. Kate Sussman is an attorney and the campaigns coordinator for the Northwest Worker Justice Project. NWJP provides legal support and education to workers in their organizations. Kate handles employment and civil rights cases and coordinates their worker safety coalition, Safe Jobs Oregon, which is an affiliate of the National Council for Occupational Safety and Health. Tom McGarity is a professor of law at the University of Texas in Austin and a board member of the Center for Progressive Reform. And Sid Shapiro is a professor of law at Wake Forest University School of Law, and he's also a board member of the Center for Progressive Reform. Tom and Sid are also co-authors on CPR's recently published white paper, OSHA's Next 50 Years, Legislating a Private Right of Action to Empower Workers. So let's get started. We're gonna do this as kind of a Q&A format. So the first question that we have today is, what is wrong with the current system for reporting to OSHA or state agencies that a workplace is unsafe or unhealthy?
Well, I can start with that one, if it's okay with everybody. As many on this call will know, OSHA inspections prioritize imminent danger situations, workplaces that have reported fatalities or injuries requiring the worker to be hospitalized, referrals from other agencies, complaints from workers, and specific high hazard industries or individual workplaces that have high rates of injury or illness. All that sounds really robust, but it turns out OSHA inspections, unfortunately, are a lot less. They're problematic for a bunch of reasons noted in our report: severe funding constraints, the periodic appointment of administrators who are ideologically opposed to what OSHA does in Republican administrations, the agency's willingness to settle cases for pennies on the dollar, the exclusion of a large group of workers from OSHA jurisdiction, the failure to protect workers who report problems to the agency as whistleblowers, an often hostile Occupational Safety and Health Review Commission, which adjudicates OSHA violations, and the lack of interest among Democrats to try to fix these and other problems when they've been in a position to do so. Unfortunately, there's no better example of these failures than the pandemic, As indicated, one of OSHA's priorities is imminent danger, and yet it was basically missing in action in the last 4 years, including the pandemic. It received hundreds of complaints from workers about working conditions during COVID, and it did almost no inspections and fined almost no one. Yet we know beyond a fact that many of these workers faced imminent dangers in their workplaces, such as packing plants, warehouses, and other locations. So these problems have been around for a long time. Tom and I noted them in a 1993 book, and unfortunately, they haven't gotten a lot better over the years. So that's what led us to think about the need to empower workers to sue on behalf of themselves to enforce the OSHA Act.
I'll jump in here too. And everything Sid said is, the basis of the problem. I think what it results in is a culture where employers know that they can break the law. There's just a culture of non-compliance. And unfortunately, workers know this too. And it's left workers with very little faith in OSHA. And that's true for federal OSHA and state plans. Like in Oregon, where I am, we have a state plan and a very well-intentioned OSHA, but they, as Sid said, really are not able to meet the challenge, even in a normal year. So the real problem from my point of view, and I work mostly with low wage and immigrant workers, is that the claims that should be brought aren't being brought. People are suffering through really dangerous conditions, and fatalities and injuries are happening for low wage and immigrant workers in really alarming numbers. So we could probably spend the whole panel talking about the problem, but I think many of you on the call are involved in this work and understand just how serious this problem is with the way things are currently enforced.
Thank you. So preparing for this panel, I talked with one of my colleagues at CDM, and last year CDM filed an OSHA complaint on behalf of 2 migrant worker women in the H-2B program. They're crawfish workers in the state of Louisiana. We went through the whole hoops. Unfortunately, we lost the case, and so I asked her. I said, "Hey, what do you think? Do we really need a private right of action?" And her response was like, "Totally, yes," because it becomes an employer versus worker, right? And who does the investigator ultimately believe? How do biases play into these cases, right? And which side ends up being the more credible party in all of this, right? And for us that are advocating for workers in these spaces and low wage industries, workers of color, we know that we have an uphill battle when it comes to overcoming the biases that are inherent in all of these agencies that are tasked with enforcing workers' rights.
Thank you. So our next question is, what is a private right of action?
And I'll take a first stab at that. Private rights of action have been around since the early 1970s, when Congress enacted the Clean Air Act, the Clean Water Act, and then in subsequent environmental statutes. The essence of the private right of action is there needs to be a violation of a federal law. It can be a permit. In the case of EPA, it's often about permits, but for OSHA, it would be a violation of an occupational safety standard, an occupational health standard, or the general duty clause. So you have a violation of federal law. The entity filing the action first must give the agency, the relevant agency, notice. And the length of that notice varies. But the idea is put that agency on notice that there's a problem here and you need to deal with it. If the agency doesn't deal with it within a prescribed period, again, which sometimes varies among the statutes, then that entity, in our case, it would be the worker, or perhaps an entity representing the worker, files the lawsuit in a federal court and challenges the violation of the law. If the, I guess it goes then to a trial where the plaintiff proves the violation. If the plaintiff does prove that violation, then there is a possibility of injunctive relief if the violation is ongoing, or the possibility of a fine or a penalty. And that penalty under the current statutes goes to the federal government, although there are various workarounds to try to get the penalty spent on things that are more relevant to the problem than just reducing the federal deficit. So that's the essence in a nutshell of what a federal right of action, a private right of action consists of. That's and it's proved, and I'm going to speak about this probably a little later. I don't want to take up too much time now. It's proved to be very, very successful.
Yeah, I'll just add that we're talking about specifically a private right of action in OSHA today, but every worker statute needs to have a private right of action. And if you pass a great law in your state or federally, but workers can't enforce the law themselves, you're stuck back in this same framework where you're reliant on overburdened agencies who often don't have the trust of the community who they're supposed to protect. So I think that, Tom really covered what the private right of action is, but just to remind folks, we're talking at every level of enforcement, we need this private right of action, not just for OSHA.
Maybe the most important part of a private right of action is it empowers workers and gives them the capacity to protect themselves. And they don't have to depend on the agency, whether it's in good faith and just doesn't have enough resources, or it's in bad faith because the people there just don't believe in what they're doing.
Thank you. And Sid, that is a perfect transition to our next question, which is, how does a private right of action benefit workers?
Well, workers are not dependent on the agency, right, as their only way of seeking prompt action, right? When we have workers are working, I mean, especially like right now in the pandemic, right? There are urgent health and safety situations that are occurring at the work site, and workers should have the option to seek and have like, I mean, they should be able to find prompt action, and it's not happening right now. We're not seeing it happen at the state and federal level. We think that having a private right of action, they would be able to get things moving faster. They would be able to address issues that are jeopardizing their lives.
There's a number of innovative efforts by worker centers, public interest organizations, other lawyers to try to find other grounds for suing Walmart and other places in tort or in employment law. And those just aren't going very well. And it's really a long way around the barn when the employer likely is committing a violation, and yet we have to go off to try to find some cause of action in employment law or tort or something to get enforcement. Why not do it directly?
Yeah, I think there are really two levels where a private right of action can benefit workers. One is just surfacing these claims that right now we know are out there but aren't being brought. And we've talked about why. So if we had a private right of action, a worker or a group of workers could find an attorney that they trust, someone at a legal aid or a private practitioner who has expertise, and have someone alongside with them who has their back during the process. So you're going to have more claims surface, and then while the claims are being brought, you'll have less fear, I think. I know my clients feel really much more safe with an attorney than they do with the state. They will show up for hearings. They will authenticate photos, find other witnesses, do the things you need to do to prove up a violation. And I know from working with our OSHA in Oregon, again, well-intentioned, but very often workers don't show up for those conversations that the OSHA inspector wants to have, or they deny the problem was there to begin with, or they've been fired, or whatever the problem may be. OSHA has a really hard time proving many violations. And I think if you had a framework like this, the whole involvement of workers would change, and you'd get a level of proof and ability to make these violations stick that is not happening now.
And I would add, there's a broader benefit to the private right of action, and that is if employers know now that employees are going to be able to bring a private right of action when there's a violation, maybe there won't be so many violations. It should act as a disincentive to employers to let the workplace safety go unaddressed.
Thank you. And Selma, you had mentioned the pandemic in your last response. I'm wondering, how would a private right of action help frontline workers who are affected by COVID?
So what we are seeing in the pandemic is who is working in the essential industries, right? We see these signs like praise, let's salute our essential heroes. We see nice videos, right? But who are the essential workers, right? Many of them are in low-wage worker industries. They're high-risk industries. Many of them are BIPOC, Black, people of color, Indigenous, and they are the ones that are suffering a disproportionate, like the brunt of COVID-19. And these are the workers who are going to work every day, jeopardizing their lives, but also exposing their families and their communities. And having a private right of action would, like Kate mentioned, right, it would allow these workers to find or come together, right, build these connections of trust to seek ways to address the unsafe conditions at the work site. We also see that the agencies may not necessarily be culturally competent, right? Or there are many language access barriers. And so having this other means of addressing these unsafe conditions would go a long way. And also, like, the goal is to get a prompt investigation, right? You want something to happen fast, but somehow the only person that can do something at this point, the agencies, are not acting fast enough.
Another advantage of a private right of action is the attorney who is bringing the action can get publicity that the action has been brought. And that draws the attention of the community to the failure of the packing plant in their community, or the warehouse, or whatever employer it is. And as we just heard, it's not only a matter of endangering the employee, this has endangered the entire community. So it publicizes that, and it publicizes it on a local level. And hopefully that in and of itself would have some proactive effect on employers.
Thank you. And Tom, you mentioned earlier that you were wanted to speak a little bit more about a private right of action and how that has worked effectively in other laws.
Yeah, I was going to give a couple of examples. Back in the 1980s, during the Reagan administration, EPA, the Environmental Protection Agency, basically quit enforcing the law. They just shut down enforcement. And there were a number of the early permits under the Clean Water Act, called National Pollution Discharge Elimination System permits that were out there, and the companies had to monitor their effluent as it went into the rivers and the streams, and report the results of that monitoring. Well, the environmental groups, and one in particular, the Public Interest Research Group, just went out and to the various state agencies said, let me see the monitoring reports. And they looked at the monitoring reports and they saw numerous violations. In fact, the violations were even circled many times. And so they went to work and they filed dozens of lawsuits around the country, basically saying these guys have got to pay. They've got to be held accountable for their violations. And it worked very well. The companies realized that just because EPA was no longer the cop on the beat, that they were still going to have to try to do what was necessary so as not to violate their permits. Another great example of the private right of action came at the end of the Clinton administration and moving into the George W. Bush administration. Right at the end of the Clinton administration, EPA did some very serious investigations of power plants, coal-fired power plants for the most part. And they discovered that a number of them were engaged in modifying their plants without undergoing what's called new source review, without upgrading their technologies once they modified the plants, upgrading their pollution control technologies, so that they were basically viewing themselves as grandfathered and not having to meet the newer requirements that EPA had promulgated. So EPA launched about 11 major cases, and these were huge cases against power companies. The Bush administration came along and suddenly the cases just stopped. They slowed down, nothing was happening. And it looked like the power companies were going to get away with it. But one thing, those environmental groups just took charge of those cases. A lot of discovery had already been done. They did a lot more discovery. And pretty soon we had huge settlements, bringing about hundreds of thousands of tons of emissions reductions in these cases, some of which were still ongoing by the time the Obama administration came up, and the Obama administration proceeded ahead with them as well. So we have two real success stories here that show that this private right of action is a very effective tool to make sure that we do have a rule of law and that those laws get enforced.
Thank you, Tom. That was really helpful. So when we're talking about a private right of action in the context of occupational safety and health, what do you all think legislation that would create a private right of action would need to include?
Our report discusses a whole bushel basket of things we think it needs to include, but maybe at the top of the list is attorney's fees. And there are other federal statutes that provide pretty good models for how this would occur. The fees have to be available if the case settles, as well as if the plaintiff wins the case. Besides making lawyers available to workers so somebody can bring these lawsuits, it also has an effect on the employer, because if they prolong the lawsuit, the legal fees they'll have to pay at the end only go up for obvious violations. So that incentive to try to exhaust the worker's resources and exhaust the worker's attorney, and therefore they'll never come to account, goes away, because it simply won't work.
So in Oregon, we're working right now to pass a bill modeled on the California Private Attorney General Act. Our bill is called the Just Enforcement Act. We've had one hearing, and we've had a lot of support from some of the leadership in the House where we're starting. But it's going to be super uphill. It's a big concept, and I think we'll talk more at the end about some of the ways that we can fight for these bills. But what it should actually entail, that's something that we've been working on with our agencies and with our coalition. We have, I'll talk more about the coalition and the work in Oregon, but more broadly, what I think one of these concepts needs to entail, for sure, the attorney's fees part is a big part, and I don't think we need to talk about that too much more, but just to say that currently there's really not a private bar for plaintiffs to bring these kind of suits. So there's not a lot of technical expertise on the workers' side. There's plenty on the employer side because they defend against these things. So we need to build that bar of attorneys up and help workers navigate this, this complicated terrain. I think you also need to have the ability for a representative organization to be the named plaintiff because of the fears of retaliation that so many workers experience. And you have to have protections for retaliation. And I'm a big proponent of early reinstatement while a claim is pending, because often, these things take forever, and it's another injustice on top of the original injustice that workers have to wait 6 months, a year, 2 years while claims are or cases are fought. And non-confidential settlements, that's another big one. If you're going to have this accountability, you're trying to bring accountability to your workplace, and in the end, you end up with a confidential settlement that has never seen the light of day. That really doesn't bring that accountability. So I think that if you are going to settle the case out of court, to have a public process for that, where you have to file that settlement in court to have it approved. I think that's a key component. And I think that Tom mentioned earlier, injunctive relief. I think that's also really important, that workers can get not just the penalties, which I think I already saw a question about, and I'm sure we'll discuss, but that an employer can be told you need to stop or start doing a thing, and then further sanctions if the employers violate the court's order. Those are some of the pieces that I see.
I would add a couple of things. One thing right out of the blocks, you need to ban arbitration clauses that force the private right of action into arbitration. Just say that can't happen, because otherwise the Supreme Court is very, very favorable toward arbitration clauses, which really just by virtue of going to work, you've signed away your right to sue. So those have to be banned by the statute. The other thing that the statute needs, and this is important for lots of things, but we need strong whistleblower protections. When that employee brings that action, if it's not brought by some independent entity like a union, so that the identity of that employee is known to the employer, there needs to be very strong protections for that employee, or you're not going to have employees filing these actions. You're not going to file the action if you know you're going to be fired, and you'll know that there's nothing that can be done about it if you are.
Let's say all of that for Maryland. In the concept of having the shifting attorney's fees, court costs language, I mean, it can mirror what we have in the Fair Labor Standards Act, right? To give workers and attorneys the possibility of taking on these cases, right? Because again, if many of these claims, these complaints are happening in low wage worker industries, right? I mean, these are not the plaintiffs that have a lot of change, right, to be paying hefty attorney's fees. So they should be, so we need to look at that shifting fees and court cost scheme.
I would add, Kate mentioned developing a bar because there are a lot of workers out there, and unfortunately there are a lot of violations. So we need a lot of attorneys in every state. But in developing the report, we talked to workers' compensation attorneys. And that's an existing bar. It exists in every state. It is attorneys who deals with workplace accidents all of the time. I think there's some reason to believe with legal fees and these other provisions we're talking about, that bar would supplement the public interest groups, the worker centers, and others who are already doing this kind of work.
Thank you. Certainly lots of elements that need to be considered and included in any legislation. So when we're talking about legislation, what challenges do you expect at the federal level?
Well, I mean, the employer community and their advocates are not going to like this provision. We already know they don't like this kind of provision. So it's not going to be easy to pass this, certainly in the current legislative climate, unless maybe the Democrats get rid of the filibuster. And we don't even know then whether all the Democrats support something like this, although I hope we could educate them to do so. But that's not a reason not to start advocating this as best we can, because the time will come at the federal level where the Democrats will have the capacity to do this. And then, as we just heard, if we develop these ideas and get them honed, there are states that can and will go forward. And so we can push those efforts in the meantime.
I think Sid's right when he says there's going to be opposition. I would just add, it's not just going to be employers. It's going to be the Chamber of Commerce. It's going to be the National Association of Manufacturers. It's going to be the Business Roundtable. All of these entities that are out there. The Heritage Foundation is going to go nuts about this. Probably the Cato Institute. So you're going to see a lot of opposition. But when you think about it, it's really such a sensible thing that the opposition is really basically in a self-interested kind of way, just saying don't make me comply with the law, and I don't think that's a particularly attractive position to take. Now, one point they will make that they've made in the past when this issue has come up that we need to have a good answer to is they're going to say, look, these unions, it's the unions, and they are going to use the threat of a private right of action for safety to bargain up wages or to bargain for other things. They're going to abuse this process. And I just don't think that's true. I think there's enough going on in the union bargaining situation that this won't play that large a role. And in any event, so many workplaces aren't unionized. When you think about it, the number of workplaces that are unionized has been shrinking over the last 20 years. So that to me is a bit of a red herring argument.
Thank you. And Kate and Soma, I'm wondering at the state level, if I wanted to push for legislation, what would I need to know? What obstacles might I run into at the state level?
Soma, you want to go first on that one?
Yeah, sure. Well, one, the politics, right? Maryland has a Republican governor. Our legislature is Democratic, controlled by the Democrats. But even then, the overall like sentiment and perception of what the role of these agencies should be, and also, I mean, we say private right of action, and to some elected officials that means like, oh my goodness, you're opening the floodgates to litigation and all kinds of frivolous lawsuits. So we have those perceptions and those ideas to push against, but something that we have seen in Maryland, right, is the coming together of number of advocates, right, beyond those in the workers' rights world of advocacy, right? We're talking advocates from public health, social services that have all come together with the goal of addressing the issues that are impacting these essential workers. And one example of that is the Coalition Marylanders for Food and Farm Worker Protection, with like over 100 members. And so that's something that I look at as promising, right? And also the fact that before the pandemic, advocates in this space, we know, right, of all the issues and all the bad things happening, but the pandemic has blown the lid off, right? It has exacerbated these issues, but it also has generated public outcry and attention. And if I think we have a combination, I think we're at a good time, right, where we could have these conversations not only in Maryland, but throughout the country to explore looking for a pathway to a private right of action.
Exactly, Sulma. Like now is the time, if we're ever going to have a time where we can show folks who aren't as informed that there are some serious problems out there that workers are trying to address, and our state agencies or our federal agencies are not equipped to handle them on their own. So Oregon is one of a couple states that's working on a statewide concept like this. I don't know that all the other states include safety and health enforcement. Washington State is including OSHA violations, as is Oregon. So some of the things that you might want to think about if you're in a state where this is a possibility or something you want to make a possibility. As someone said, employers are never going to get on board with this. They'll never embrace it. At a hearing we had on this previously, one of the employers, I think it was a Chamber of Commerce, said, well, this will just interrupt the way we've been doing things for time immemorial. And that is the point. Definitely chuckled as they said that. So you're going to need to accept the fact that you're not going to get most of your more conservative and Republican folks on board. You need a really strong coalition to fight that. So unions and other worker advocates, the high road employers, some of the business owners who are doing the right thing and who are being disadvantaged. Some of those folks are really important for telling your story. And then workers to tell their own stories about how under enforcement or no enforcement has impacted them. And those stories are often really hard to hear and really hard for workers to tell, but make it very hard to deny that there's a problem. You have to have agencies that are not dead set against the concept, which is, I know, not possible in every state. This, for some agencies, they feel like it's taking away their power. And we have tried to work with our agencies to say, we want to enhance what you're doing. A fundamental concept here is that if the agency has the capacity and the will to enforce the law, then they can go ahead and do that under a private attorney general model. If they don't have the capacity, then the workers go forward with the agency being able to be involved or take the case back if they decide to and have capacity later. So the agency issue, like if you're working with a state labor bureau or with a state plan OSHA, that's going to be a big source of the problems you need to address. And you have to make sure that they're neutral, at least. If they're out there advocating for it, you might run into other troubles where it could seem like self-dealing. So you really want to make sure you can get your agencies to a neutral position. And then you're going to need political champions who understand working class issues and workers' issues, who are willing to champion this and talk to other folks about it. And you're going to need to fight that false narrative that we've already mentioned. I think Tom just mentioned the false narrative that this is going to flood the courts and flood our agencies. And this is just about greedy attorneys and frivolous lawsuits. That is absolutely untrue. And there's, I think, every state and federally, there are sanctions and penalties for bringing frivolous lawsuits. And when you have a group of workers who's willing to step forward, maybe those claims weren't being surfaced earlier. And if that means more work for your courts or your systems, well, those claims need to come out regardless. And also we can look at California, where they've had a concept for 15 plus years. It doesn't flood the courts. It's a very small impact on the courts. And it also is a program that grows slowly. New rights are often not out of the gate the source of a lot of actions. So there's a lot of things you'll have to confront. I hope I haven't put out too many of them. And I'm happy to talk to folks offline if people are interested in trying to do this in their state, because it is a giant prospect.
Thank you. So we're going to move to the Q&A session, and we have a lot of great questions coming in. But before we do that, I wanted to ask if you have any parting thoughts, any responses to each other or the questions. And while you're thinking about that, I will stop the screen share so that we can move on to some of the questions. I'll also mention real quick before I turn it over to you guys. We are opening up to questions. So if you do have questions, please type them into the Q&A feature on Zoom, and I'm going to go through the questions, and hopefully we can get to all of them. If not, we will try and have someone reach out to you after the webinar with an answer.
There's so many good questions. I think we should get right to them.
Okay, let's get right to them. So the first one has to do with responding to COVID and the fact that hospitals have and other employers have issued gag orders. So for instance, with hospitals issuing gag orders to nurses and others and firing workers who have spoken out to the media. How would a private right of action help workers who have concerns, immediate concerns like with COVID, and protect them if they wanted to speak to the media, even if they don't identify their employer or when they do identify their employer in the news?
Well, I mentioned whistleblower protections, and if rather than go to the media, they simply have a lawyer that goes to court, that's a public proceeding, and the media ought to be following it. So it'll get in the media, and if they have this private right of action with whistleblower protections, then the story will get out, and they shouldn't be fired, and the gag order should not. And maybe we should put into this legislation something about gag orders as well as arbitration clauses, but the gag order sounds to me very much like an arbitration clause, which is attempting to force the employee away from something they have a right to do.
Yeah, I'll just add on there. I think a lot of the question's gone, but I think it's related also to the second question. I think that it's a tactic employers use to silence workers, is to threaten lawsuits, defamation. That comes up a lot. With threats of defamation, I don't think the employers actually have any intent to go to court, because it's very difficult to win that type of case when workers are out there telling the truth about their experience, but it has a real chilling effect anyway, especially on workers who are new to organizing and new to speaking out. If an employer comes to you and says, I'm going to sue you for saying untrue things about me, that has a real chilling effect. So I think that that is a risk. That's a risk already with all of our workplace laws. And it's something we all need to do to educate ourselves and educate each other on the risks, I think minimal risks of an actual defamation suit for a worker who's telling their truth.
Thank you, Kate. So the next question, I think, is for a point of clarification. The question is it true that the result of a successful suit is that the fines collected would go to the U.S. Treasury instead of relief or restitution to workers? Can you talk a little bit about the portion that might go to the Treasury versus what might go to workers who succeed?
I can talk a little bit about that. The best model, in fact, although these things vary under the existing private rights of action, is that the worker and the Treasury will share the penalty. And we put in the report as an example that the worker would keep 30% of the penalty and the rest would go to OSHA. And as Tom mentioned earlier, maybe that could be limited to then be spent on areas of OSHA that are of particular interest to enforcement. This is important in several ways. One, it further incentivizes the worker. Second, it's a little technical, but we were a little concerned in the report about standing problems and whether these lawsuits could overcome the issue of standing, that the worker has an actual injury that qualifies. And we think maybe that's the case, but the Supreme Court has also mentioned that if you have a monetary interest in the outcome, that can also give you standing. So there are good reasons to share this, and other statutes do that, and we should.
Thank you, Sid. So the next question is filing a safety grievance with your union a variety of a private right of action?
Well, it kind of is. But that all works, of course, through the NLRB process. So it doesn't get you directly to court. It gets you to the possibility of bargaining about it, or arbitration. Very often it's an arbitration about the particular grievance. I think the private right of action would be considerably more powerful than just pursuing a grievance through the NLRB, although my daughter may disagree. She's the chairman of the NLRB at the moment. But I do think that the private right of action would be a bit, would be more effective.
Yeah, and just to add on, you have a very personal relationship there, Tom. But many workers are not unionized, as we all know, sadly, and it's a trend that's
Right.
thing, and we're seeing some really encouraging signs. But for the many workers who are not part of a union, this is a really different option. And yeah, you still have your rights under the NLRA if you're working together to improve safety in your work site. But this would apply to all workers, not just unionized workers, and there'd be a whole level of publicness or daylight. I think that would be, as I think Sid mentioned earlier, that could come along with this.
Thank you. These are great questions. Please keep sending them in, and we'll see how many we can get through before the hour. The next one is for Tom, or anyone can answer, but it was about Tom had mentioned the NPDES violations under environmental laws as the low-hanging fruit of Clean Water Act citizen suits. What do you think would be the low-hanging fruit of a private right of action for an OSHA case?
Well, that's a good question. There are lots of regulations out there that are pretty specific. They're written in very precise terms. Some of them are still remain from the old emergency. Well, what was it was called when OSHA was enacted back in 1970? The
Consensus standards.
Yeah, the consensus standards. Thank you, Sid. So they present low-hanging fruit because they have OSHA gets criticized for it sometimes, but they specify, just how many feet or how many inches or just how tall the barrier has to be. I think in the age of COVID, there's some pretty low-hanging fruit as well. Although it depends on the workplace now. Some have improved dramatically. I think there's still some workplaces, quite a few workplaces out there where there's low-hanging fruit in terms of not taking adequate protections for the workers. So that's a couple of suggestions.
Thank you. So the next question is, could workers who sue their employers remain anonymous as they do when they file an OSHA complaint?
Yes, that's really important because as we described, the threat of retaliation is real and it's significant and it's a real problem. And backing that up, as we've been mentioning several times, is the existing state of whistleblower protection is not good. OSHA is also the agency. The Department of Labor is responsible for whistleblower complaints. But that's not working very well. And I think the advice that we heard earlier that as we think about legislation, we have to also think about building more effective whistleblower protections into this legislation and not depending on the existing legislation.
But in terms of remaining anonymous, I think if we develop a robust system of employee representation, I think that you can craft the private right of action statute to allow an entity that's representing a worker to file the claim and thereby protect the identity of the worker, at least to a point. There may come a point where you need testimony about what it was that the worker's complaining about, and the worker is really the only person, or some workers, the only person that's able to make that testimony to make the case go. Then the anonymity may suffer.
Thank you. So the next question is, do you know of any unions that are strategically connected to this effort? And also, do you know if this is on any legislative dockets or has it been in the past?
I can speak to in the state, some of the statewide efforts in both Washington and Oregon. The AFL-CIO has been really active and involved. In Oregon, the UFCW and our farm worker union, PECUN, have been, this is a priority for both of them, as well as carpenters and our laborers. So in Oregon, we have huge union support for the concept. And that's true in Washington state as well. I'm not as much sure in other states or federally.
Unions are a source of being plaintiffs. So we talk about ununionized workplaces, and it's a huge problem. But in those that are unionized, the union may have more success in protecting its workers. It may not, but it is available to sue the workers, and it becomes another entity, as Tom was mentioning, to sue on its members' behalf. And the lawsuit would be named as the union lawsuit.
And to that second part, do you know of any legislative efforts for a private right of action in the past or currently?
I think there's some interest on the Hill in Washington in some offices. And one of the reasons we brought out this report and tried to discuss this in some detail is to give us a vehicle, us and other allies, anybody, to take to people they know in the offices on the Hill and start that educational process that we need to start for the moment when it becomes possible to pass legislation like this. So that may take a while. I hope not. But with this report, we hope people will be equipped to do that.
Thank you, Sid. So the next question is about success at the state level. Given that there's a filibuster at the federal level, it looks like we might see more success at the state level going forward. If a state is in a OSHA state where federal OSHA is in charge, would the state be allowed to create a private right of action? And the question goes too for states that operate their own programs. Would they need to amend their program or create legislation to do that?
Tom, were you about to speak, or do you want me to answer that? Tom, you're muted. I don't know if you know that. The old problem on Zoom. Am I muted or not? So yes, as far as we know, workers in states that are not OSHA enforcement states could establish a private right of action. The OSHA Act itself doesn't really speak to this one way or another. And we think the argument is that it would be a hard case to make that this is somehow preemptive at the OSHA level, when the legislation would add this to state rights. There could be a state right of action for an OSHA violation, we think.
Yeah, it is a bit untested federally, and it's about half the states that have their own state plans. So yes, you could do this in other states that have their own OSHA more easily, but hopefully many of us are going to keep working to push out the idea federally and to see how much we can do there.
Great, thank you. So the next question is about the need for technical expertise in conducting inspections. How would a private right of action address technical expertise concerns when there's no union present?
I think that's a very good question. When it comes to more sophisticated things like occupational health standard violations, that's going to be very, very difficult. I don't have a real quick solution to that, because you're going to have to do monitoring to the extent that the standard requires monitoring and reporting, and we do need a lot more a more robust reporting system from OSHA, and I think we're going to get it in the Biden administration. Then those reports will be available as the OSHA inspectors provide come up with them. So in that kind of context, what the private right of action offers is a vehicle to move the ball forward when the OSHA inspector comes out, detects the violation, and writes up a report, and things just stop. The private right of action will allow you to go forward and push it forward based on the OSHA report. Beyond that, if you don't have a union to have access to the workplace to do the or to bring a technical someone with technical expertise into the workplace, that's going to be a difficult problem.
And a follow-up to this is it says the track record of private plaintiffs seeking interim injunctive relief under Title VII and other workers' rights laws with a private right of action has been pretty dismal so far. Does the proposed private right of action that we've been speaking about, would that solve the problem from those current laws?
Well, I'll answer that with respect to another question I saw there, and that is we've got a Trump judiciary, or a lot of judges now that have been appointed by Trump. I think the big difference is we're talking about safety here. We're talking about people dying or are becoming sick, and I think that will be more persuasive when it comes to persuading a judge to provide injunctive relief. But it's always a hard row to hoe to obtain injunctive relief, because there's a balancing process that's involved, and some courts are much more reluctant than others to force a company to take some action or to stop some action.
Thank you. And some of this one's for you. How would the private right of action help international labor coming with H-2A and H-2B visas? It says these workers are not union most of the time, and they can lose their status if they're fired.
Yeah, so the issue of the temporary work visa programs. So in our advocacy, right, in looking at a private right of action, we also have to look at the access to justice, at the statute of limitations, right, and what safeguards are in place, because the workers in these programs, I mean, otherwise known as guest workers, their employment authorization and their visa are dependent on their employment. And if their employer decides that, you know what, you're not complying with my rules, then they will turn over the worker to DHS and ICE, and the worker falls out of status. That is a huge obstacle, and that is something that hangs over the worker, right, in trying to decide whether or not they're going to even say something, much less file something. And then even a decision to file, I mean, if they make that calculus of like, I'm gonna go ahead and do something, then at that point, they know that they will most likely be opening a Pandora's box. They have the they're losing the status, and also who is going to be working with them to help them navigate the complex legal system in the United States, right? So there are many, many things that, yes, we're talking about private right of action, but also thinking of all the realities of the workers that may come forward in filing these types of actions.
Thank you. And we have dozens of questions still coming in, and thank you everyone, but we have reached the hour. So I'm going to close this out. I will say that you will receive a survey after the close of the webinar. Please fill that out. We'd love to keep in touch with you. Please put in there if you have other questions that did not get addressed so that we can reach back out to you. And also for everyone who's here, you will receive a recording of the webinar, I believe on Monday. So please look out for that and reach out to us if you have any other questions. Thank you so much to Solma, Sid, Tom, Kate. This has been tremendous, a great conversation, and I look forward to talking with you about it more.
Take care.